Good evening. It's 6 o'clock in southwestern Ohio and south central Ohio, wherever we are, Beavercreek, Ohio. And it must be time for our October Board of Zoning Appeals meeting. So I'm calling this to order. Ms. Gillow, will you call the roll, please?
Mr. Botla.
Present.
Mr. Clunin.
Present.
Mr. Essman.
Here.
Mr. Rust.
Here.
Mr. Archibald.
Here. Okay, everybody's here. Good. We have an agenda with a couple of hearings on it tonight. Are there any additions, subtractions, modifications to the agenda? Hearing none, I'll ask for a motion to approve the agenda as written.
A motion to approve.
Okay, we have a motion to approve the agenda as written. Do I have a second?
A second.
By voice vote, all in favor?
Aye.
Any opposed? Hearing none, the agenda is hereby approved. We also have some minutes from our August 9th meeting. Hopefully everybody's had a chance to review them and make any annotations. Any corrections or additions or modifications to the minutes from the August 9th meeting? Okay, seeing none, hearing none, I'll accept the motion to approve the minutes as written.
So moved.
Okay, we have a motion. Do I have a second?
I second.
And a second by voice vote. All in favor of approving the minutes of the August 9th meeting as written, say aye.
Aye.
All opposed? Hearing none, the minutes from August 9th meeting are hereby approved. Okay, moving right along. A couple of cases. And Ms. Gill, the floor is yours.
This is case number V23-7 on an application filed by Marland Ellis, 1850 Andrea Circle, Beavercreek, Ohio, 45432, requesting a variance from Chapter 158.104A of the City of Beavercreek Zoning Code to construct an accessory structure within the required 10-foot side yard and 10-foot rear yard setbacks. The property is located on the east side of Andrea Circle, 7 lots south of the intersection of Fairwood Drive and Andrea Circle, further described as Book 5, Page 1, Parcel 134 on the Greene County Property Tax Atlas.
Okay, thank you very much. Mr. Funk, tell us what the staff thinks.
Thank you, Mr. Chair and EZA members. So what we have before us is, as Melissa read, case V23-7, 1850 Andrea Court. Basically, this is a location. It's up off North Fairfield Road. So it's on the kind of the northern side of town. This is our infamous drive-by.
Thank you.
So this is the applicant's house, and what you'll see in the back on this one side is the shed in question. So basically, the applicant is requesting a variance from our side and rear yard setbacks. The applicant, basically where this originated, city had received a complaint about the structure being located too close to the property line. So our code enforcement went out and did an investigation and determined that not only was it appeared to be too close to the property line, there was never a permit pulled for the shed. And so the code enforcement officer basically issued a notice of violation, basically informing the applicant that they needed to get a permit and all that. So the applicant basically has yet to get a permit, but he's filing this variance, and preceding that, he's filing this variance to an attempt to allow the shed to be located basically 4.5 feet from the side yard setback, and then 1.5 feet from the rear. So what you can see in this photo, basically the applicant had a shed that basically he replaced. So 2001 was the old shed, and then the photo from the spring shows the location of the new shed. The applicant supplied us a picture, and that was in your packet of the shed from one angle. This is a picture from when the code enforcement officer was there to take a picture. The applicant supplied basically this photo showing that his distances, basically the applicant is stating the fence is on the property line, so that's the distance from his from the side fence. And then the applicant is stating that basically his property line is basically is on the other side of his fence. So basically he's 8.5 feet from the property line. His fence is in for a little bit. So basically he needs a 1.5 foot setback encroachment into that rear yard setback is what he currently has. So here's another kind of image, GIS, as we discussed in previous meetings. These aren't 100% accurate, but they give you a general idea of, I think this one's pretty close. When you look at where the front property line is in relation to the sidewalk, this one's going to be fairly close as far as where those setbacks are. So the red is the setback, the yellow is the utility easement. So on this property, there's just for clarification, there's a 10-foot utility easement on that west side of the property. So the applicant is actually encroaching 1.5 feet into that utility easement. And then on the southern side, there's actually a 5-foot utility easement, and the applicant is just outside of that utility easement by 1/2 foot. So basically, in looking at our criteria, basically staff has determined that basically there's nothing unique about the property that is creating a practical difficulty that would prevent the applicant from building a compliant shed. As you could see in the photos, he's got a lot of space, it's flat, there's nothing really unique there that would have prevented him from putting it in a compliant location. Secondly, the applicant does have the ability to comply with the zoning code, so there really is kind of negates the necessity for the variance. Number two is the variance being granted is the minimum variance possible, or other alternatives in resolving the conflict are there. So the applicant does have the ability to put the shed in a compliant location. The third criteria is it in harmony and general spirit and intent of the purpose of the code. Staff does not believe that the applicant meets this criteria as well, because those setbacks were established, they're executed uniformly across the outside of a variance, uniformly across the city, and it just doesn't fit that general spirit and harmony of the code. The next one, number 4, kind of took a neutral position on that because I don't believe that the granting the variance would be directly injurious to the surrounding properties, but in the instance that that utility easement had to be accessed from the rear, as we've discussed in previous meetings, may potentially cause an issue if the utility company has to exercise the full width of their easement. Which obviously would probably, the chances would be minimal that there was ever an event that was so critical that it would impair, the surrounding properties, but the possibility is there. So we kind of took a neutral position on that. Would the granting of the variance have a deleterious change to the character of the community? I don't think it would, because staff doesn't believe it would. There was a shed already there. There's a shed there now. And would it infringe on the quiet enjoyment of the neighborhood or the surrounding community? Again, staff does not feel that that would. So we do believe that he probably met those 2 criteria. Is the granting of the variance for a compelling reason? Staff does not feel that it is a compelling reason. The staff does have, the applicant does have the ability to, locate the shed in a compliant location. It's just, the applicant's plans for the location of the shed just conflict with the zoning code. Now, the applicant, did state that, he had conferred with some contractors who told him he didn't need a permit to put the location there, and I, completely understand that. As staff, we completely understand that. But the reality of it is conflict is with the contractors, not the city. And so again, staff does not believe that that's that he meets that criteria. The applicant did get a fence in 2019, and there was a permit. He replaced the fence in 2019, and there was a permit issued for that replaced fence. So there just wasn't one for this replaced shed. So the last criteria is the granting of the variance solely for an economic reason. Staff believes that the applicant does have ample space. There is the ability to locate it in that position. The only thing that's preventing that is the economic impact of the cost of relocating the shed. So therefore, staff does not believe that the applicant meets that criteria. So staff, basically, based on the criteria, recommends disapproval of the applicant's variance request.
Okay, thanks, Matt. Okay, is there someone here representing the applicant? If you would, please come to the podium, and up in the upper left-hand corner, there's a little card up there, if you can read that card.
I,
For the record.
Marland Ellis, affirm that the testimony that I am about to give before the Board of Zoning Appeals of the City of Beavercreek is the whole truth, to the best of my knowledge.
Okay,
Thank you, Mr. Chair, and to all the members present. My name is Marland Ellis. My wife and I bought this property in 2005 when we moved here from a previous military assignment. We looked specifically in Beavercreek because we like the school systems here, and we love the property that we purchased. It's a beautiful neighborhood. And when we moved here, that shed was in the corner, and if you have access to attachment 1,
we do?
you can see that it was in the rear corner. Also back just to the right rear corner, that you see a node there of utilities. These utilities include the power line, the AT&T telephone lines, Spectrum, AT&T fiber, and other optical fibers have all been put between that space, between the fence and the old shed, and run down that side of the property and over to the house. Anyway, we've used almost all of our disposable income over the last 18 years making improvements to our property, over $100,000. And in 2021, we decided that the shed had to go. You can see in attachment 1 how bad the shingles were. The doors were hanging off the hinges, and I repaired them as many times as I could. So I contracted a concrete contractor to rebuild the pad underneath the shed and extend it out a portion. And I contacted a contractor to build a new shed in the exact location that this old shed was. And both of the contractors said that based on the fact that it replaced the existing site location exactly, that there was no requirement for a permit. Mr. Funk repeatedly stated that it was within our ability to move it to the proper location. I would say to that, there is no easy way to do that. If that had to be torn, it would have to be torn down, because that shed is built on site on the pad. It cannot be picked up and moved, and the concrete would have to be torn out and replaced. This can only be done, my wife and I are military retirees, and there's no way we could afford to do this over again. So we would have to go to court in a lengthy court battle against these two contractors to make them make it right. And we did not know about these permit requirements. And I asked both the contractors to pull all applicable permits during this process. And their determination was that no permits were required. So I'm asking that you grant this variance. In attachment 2, you can see how all the utility lines fed between the side of the new shed and the south property line. Matt identified the one side, the back side of the yard as the west side. It's actually the east side. Attachment 4 shows all the neighbors who are within visual range of that property, and they all wholeheartedly endorsed the improvement that it made to the entire community. And in attachment 5, of course, you can see that it causes no impedance on any of the adjacent properties. This rear property line back here, which is on attachment 5, this is the east boundary of our property. I think it was last year, MetroNet came through there and they trenched all the way from out at Fairwood Avenue all the way down that southern property line, or east property line. And I went out there and asked him, I said, does this impede your ability to put this new fiber optic network in? He said, absolutely not. There's plenty of room. Because there's about 8.5 feet back there to my edge of the property, plus 10 feet on the other side of that. And all the utilities that have been brought into my property have come through that distance of 8.5 feet at the front and 5.5 feet at the rear. So in order to avoid having to go through a lengthy and extensive lawsuit to ensure contractor compliance, I'm asking for this variance. Thank you all for your time.
Thank you, Mr. Ellis. Since this is a public hearing, and I see people in the audience, some of whom may like to speak for or against this variance request, I will open the public hearing, and I ask that you limit your comments to 3 minutes. If somebody else has 3 minutes they want to allocate to you, then you can continue on for an additional 3 minutes. Sir, please read the card up in the upper left-hand corner.
My name is James Fountain. I'm at 1888 Rich Court, 1 block away from Marland. And I affirm the testimony that I'm about to give before the Zoning Board of Appeals of the City of Beavercreek is the whole truth to the best of my knowledge. I just moved into the area in December. I live in a big old Tudor on a hill in Beavercreek, and one of the things I've noticed is how many people, I do not, but how many people have riding lawnmowers and need sheds, and because you don't put a riding lawnmower in a garage, or you have big old lawn care equipment, because we all have half, 3/4 acre of land. It's a lot of grass. So the sheds are needed, and they look great. And I've been, since December, watching all of my neighbors in the Brentwood Sub 2 start adding sheds. Hopefully they've got permits, but I've seen 2 or 3 sheds go up. I haven't seen Marland's, but I've seen others go up. So you may have other people coming up here as you discover the sheds in your drive around. But I wholeheartedly support it because it's a lot better than seeing a riding lawnmower sitting out at the end of the driveway. It makes for a much nicer thing. So I give full support to Marland and his wife for the shed.
Okay. Thank you very much for your input. Anyone else? Okay, seeing none, I am going to close the public hearing at this time. Oh, Ms. Gilwell, do you have any written input?
Yes, I want to read into the record that the board did receive as part of their packet a letter with 5 signatures from surrounding neighbors supporting the variance.
Okay, so entered into the record. With that, I'm going to close the public hearing, and we're going to open it up for board discussion, and I'm going to start with Mr. Clunin.
I feel like I always get to go first. It's an honor.
All right.
No, it's okay.
I'll flip it over to Mr. Ross.
I was going to say, it's an honor to go first, so I'm happy to do it.
Okay, great.
I guess the question for Mr. Ellis, if you don't mind, probably come back up to the podium. I'll have a couple, but just curious. You mentioned the contractors had told you there was a permit or no need for a permit for this.
That is correct.
Have you spoken with them since, receiving the violation, asked if it's something, that they should fix under a warranty or anything like that?
I asked both if they had pulled permits. John Mintel is the Product Service Division Manager for Tom's Mulch, who did the concrete work. I contacted them. They had nothing on record. And I also contacted the gentleman who built the shed, and he restated that there was no need for a permit because it was built on the existing location of the previous shed.
Are they aware that since it was installed at least, though, that there's potentially an issue with it, whether it's a permit or need for a variance? Have they
Well-
expressed a willingness to maybe make it right, fix it?
Well, no, of course, they wouldn't just offer something like that up, and neither did they offer any other supporting evidence as to why they did it the way they did. And I think it's understood that they now know that a permit was required, and they're probably on guard for what would follow if this variance is not approved, and that would be legal action. Well, first I would call them and ask them to make it right if the variance is not approved. And if it is not, then, like I said, we'll have to take legal action. So I hope it doesn't come to that.
Sure, gotcha. That's all I have for you, Mr. Ellis. I appreciate it.
Thank you, Mr. Clunin.
Yeah, I'll let somebody else go, and I'll reserve my right for seconds here.
Okay. All right, let's jump on over to Mr. Rust.
Yeah. So Mr. Funk said that there were a number of other locations on the property that a shed could be relocated to. I just want to know if that's, if you agree with that assessment. I see a bunch of trees and different things like that. Is there any reason other than financially that there would be a problem with moving the shed?
No, it would just be, like I said, I don't think these people will voluntarily tear up the concrete pad and attempt to move the shed, which has no foundation other than the concrete. If they try to lift that up, you could lift sheds up on skids or whatever and move them. This has no basis to be lifted up. This would probably require a complete rebuild of it. I just think it would be economically unfeasible for me to do it.
With what I'm getting to is a little bit of would you have to tear down a tree or anything of that nature to put it in a different area of the property?
No, there's space back there where it could be done.
Gotcha.
But please, I asked in good faith for these gentlemen to put these two items where they needed to be. And I took them on faith when they performed those functions, which cost about, I think, $17,000, $18,000 for both items.
And just one more question. Was the whole concrete slab that was there originally tore up and repoured, or was it just an extension of the original slab?
It was, the concrete that was there was not serviceable, and they repoured the entire new pad.
Gotcha. Okay.
Thank you, Mr. Rust.
Thank you. That's all for me.
Okay. Mr. Essman.
First, thank you for your service and your wife's service. Is this new shed on the same footprint, in the same footprint as the old shed was?
It's within a foot or so on both sides of
Bigger,
being-
smaller,
The new one is bigger,
by about a foot on each side?
approximately, yes.
Okay, thank you.
That's it. Wow. Okay. Mr. Butler.
Thank you, Mr. Chairman.
Microphone.
Thanks, Mr. Ellis. You said that you are not familiar with that zoning codes, that you need to apply for permit for any construction, detached, or any improvement?
I would dare say I bet there's not even a part of 1% of the people in Beavercreek that have read the code books that would have any idea that that was a requirement. I did not know that, and so I asked my two contractors in good faith to ensure that a permit that permits plural, if applicable, would be pulled. And they told me it was in their professional determination They weren't required. So I took them at their word.
In 2019, you said you installed the fence. Did you install the fence in 2019?
That is correct.
And you applied for the permit, right?
Uh,
That's what you mentioned.
Yes.
You applied, so you knew the permit is required.
For the fence,
Yeah.
I asked my contractor if permits are required, pull the permits that are applicable for this, and that person did, apparently. I'm totally unaware of whether it was pulled or not. I counted on my contractors to do their job.
My understanding is that when you build something, it's a primary owner responsibility to make sure that permit is applied, granted, approved, then you do something. Contractor is there to assist you and guide you. So in this case, seemed like he has not been honest to you or ignored it or whatever, and you incurred $18,000-19,000 to demolish the existing and put the new one, and of course this is improvement from the previous one. And so it's a lot of money you spent it. We really empathize with that. It's not a small change, and so you are in a kind of very difficult situation. What to do with that? But like I say, you knew permit was required for fence, but in your letter you said that we had no knowledge of the city code requirement when we renovated this area of our yard.
Sir, if I could correct you, you said that I was aware that a permit was required for the fence. I was not aware.
Yeah, he said, okay, yeah, you said we had no knowledge of the city code requirement in your letter. But when you installed the fence, you did apply for a permit.
I did not. The contractor did.
Okay.
So I had no knowledge that a permit.
He did for the fence.
Yes,
I
sir.
see. Okay. So, yeah, what happened when people kind of make a statement that they have no knowledge of permit requirement, and not knowing is not excuse in a way, we all should know the requirement of building anything that city requires. So anyway, so that's,
Thank you, Mr. Butler, for the question, but again, I would say nobody in Beavercreek can quote the city codes, the codices, all the rules and regulations for what the city of Beavercreek requires, and I claim my innocence here.
That's all, Mr. Chairman, for me right
Okay.
now.
I'm sure everybody reserves the rights for seconds. Okay, thank you. I need some pictures. Can we go back to the one that shows the two sheds, for the aerial view of the two sheds?
Yeah, just
Yep.
for clarification point, that obviously, you can see in the 2021, I probably need a bike run, 2021, the footprint of the shed in 2021 versus the footprint of the shed in 2023, the two different photos, as far as the size. Obviously, some of that's going to be overhang, but the shed is larger. And just for clarification, I mean, staff certainly empathizes with the applicant and their predicament. It actually is a very nice shed. But I would contend that the city does a pretty good job of trying to advertise through the InTouch, through the website, through, we get shed replacement permits a lot, and we get calls from people all the time. Do I need a permit to do X, Y, Z? So it's not that we're hiding this information from the general public.
Sure.
On the contrary, we go out of our way to try to make sure that the public knows through various forms of advertising, through, like I said, InTouch, through website, through, all different means to notify, the public of the need to obtain permits even for, replacements.
Sure. So don't go too far away.
Sure.
But, Mr. Ellis, wanted to ask you a question before.
Yes, sir.
So, in looking at these two pictures, it looks like the back right corner of your shed, your previous shed is the same as the back right corner of the new shed.
I would
But it-
suggest so, yes.
But it looks like the new shed is actually closer to the back property line. Is that a fair assessment?
No, sir. I don't think that's the case.
Okay.
Not to my knowledge. I thought that the southeastern corner, which is the lower right corner of the new shed, I believe was situated exactly where the previous shed sat. I would also like to point out to the board that these blue lines representing our property are not correctly positioned. These are approximations.
Sure.
And Mr. Funk also confirmed that to me over the phone.
Right.
I would point out that in the it's more difficult in the 2023 photo, but that southern border line does not touch the edge of the shed. There is a green shadow line just below the property line. That is actually where the property is. And in fact, the southern fence line is built exactly on the property line. It is not on top of the shed, as
Okay.
is suggested in that photograph.
Okay, so that was going to be another question of mine. The fence is on the property line, your southern fence.
The southern fence is, because my neighbor and I both shared the expense, and we had a surveyor come out, find the surveyor marks and to the node in the rear corner. And so we decided, since we were paying an equal share of that portion of the fence, we would put it exactly on the property line.
Okay, all right. There's a good reason that we asked that, is because in one of our last cases, our previous cases, we had asked to have a survey done, and we adjourned and came back, and the survey actually adjusted the property line so that the homeowner was more in compliance than what was previously suggested. Right, so it's good to know that that is on the property line. Okay, Mr. Funk, footprint.
Yes, sir.
So the new shed is a building and an overhang, all that sits on top of a concrete slab, right?
Right.
So where does that is it the footprint for the building? We talk about this all the time, right?
Right, so the footprint would be the entirety of the building, the enclosed and unenclosed portion of the building would be the footprint of that structure. Because at any time, and we've had this issue with buildings, exterior buildings, where someone will build a structure and they'll only enclose a portion of it to be in compliance, but then down the road, they add a wall,
Sure.
and next thing you know, they've got, double the size. So to combat that, basically we enclose the entirety of that, roofed area as the footprint.
Sure.
Wherever there's footing needed, that the area of the footing, would be considered in the footprint of the structure.
So that north area is not considered an overhang?
Yeah, right. It's still considered, it's calculated in the square footage of the accessory structure. Now, how the county calculates, obviously, the applicant didn't get a zoning permit, so it's not likely they got a building permit. So, that's for him to then take up with the building department as far as whether or not he needs a building permit and what their requirements would be for that same structure. I can't answer those questions, but certainly from our perspective, he would be allowed to have most likely be allowed to have that size shed, given it was built in the proper location. So,
Sure.
at this point, our requirement would just be the zoning permit, and you'd have to take up the building part of it with the building department.
So zoning-wise, if that shed were a foot, 2 feet, whatever feet away, he could build that shed, that size?
Most likely, yeah. He hasn't applied for a permit, So obviously, we would obviously look at what easements are there and all that kind of stuff in that
But
process.
size-wise?
Size-wise, I would say give him because he's allowed to have up to 50% of the footprint of the house, so, and he has no other accessory structure. So
Right.
our concern is not the size of the shed, it's
Okay.
basically the location of the shed. And I don't,
Thank you.
again, I can't speak to the types of footings that he has, whether the shed is on skids or whether it's on piers or, depending on even the construction of the shed, it could be that the slab could be expanded and the shed could be, moved over. I mean, we have the slab is not the issue.
You're preempting my question. Go
Okay,
ahead.
sorry. So the slab is not the issue. He could have the slab, it's the structure that's the issue. So if they expanded the slab and moved the structure over, that would be, as long as it met our zoning requirements, that would be fine. He would just have some extra concrete in the back that he could stack some firewood or something on that,
Okay.
but the slab is not the issue, it's the structure.
Okay. Thank you for now. Let's see. I did have more questions for you. You can confirm that there was not a permit pulled for the original shed, is that correct?
Yes,
Or a variance request?
we have no records of the original shed nor the shed that was just built.
Okay.
Or the more recent shed. We don't have any records for either shed. So, obviously, the original shed was, a non-conforming, illegal shed that, that's how we correct a lot of these problems, is when those sheds are replaced, we require a zoning permit. So the new shed can be located in a compliant location. Unfortunately, and that's one of the main purposes of having a zoning permit is that, so, people can comply with the code and
Right.
nonconformities could be brought into compliance. It's just unfortunate, because we try to avoid these situations as much as possible because, we certainly, like I said, empathize with the applicant and the situation that he's in, certainly.
Okay, thank you. So, Mr. Ellis, it's a very nice shed, and it's a shame that your contractors didn't think that it was necessary to at least check to see if there had been a permit on the original shed, or a variance request that had been approved to put the shed in a non-conforming space, or non-compliant space, I should say. But I hope you fully understood what Mr. Funk just said, that the pad doesn't necessarily need to move, but if you expand the pad and moved the building, then you could be in compliance. Hopefully that you have something in writing with the contractors that said, please pull the permits, that are necessary, and then saying, no, there's no.
Do not.
There's nothing that, no permits needed.
Again, I trusted them to do their job, and so
Right.
now,
Yep, totally understand.
if I go back and pursue legal matters against them to make this compliance of a matter of a foot or two here and there, they have no basis for being required to do that because of that, because I didn't have them sign that in writing. I would also remind the board, sir, if I may, there's 10 feet on the other side of the property line. There's a 20-foot swath around properties. And I would just ask that you consider that in approving this variance, that there is plenty of room for any future projects that need to be done through there.
So, I'm not fully sure I understand what the 20-foot swath that you're talking about.
There is a 10-foot easement on either side of the property line, is that correct, sir?
Yeah.
So that's
Is it
20
10 feet? It's only 5 feet on his side property, right?
So on the east side of the property, so on the eastern side of the property, there's a 10-foot utility easement on the applicant. And then on the southern boundary, it's a 5-foot. So, and
is it-
he's outside of if based upon his distance to the fence that, the applicant states is on the property line, then he's outside of the utility easement on the south property line, and he encroaches 1.5 feet from into the easement, utility easement on the eastern property line. But he needs a 4.5-foot encroachment to that south property line, even though he is outside the utility easement on the south. And he needs 1.5 feet. He would need 1.5 feet variance on the eastern side.
Sure. Can you put up the slide with the measurements again? What?
So that's the applicant's picture that he submitted, and he's trying to depict with that green line roughly where the property line is on the other side of his fence. And then there's this one that he's
Right.
showing the distances to his fence. He said, the applicant's stating that fence is on the property line because he jointly constructed that fence with a neighbor.
Right.
Where the other fence is actually encroaching, is moved into his property. So.
Okay. So our responsibility here is not enforcement, but approving or disapproving a variance request. I don't know what if your request should be disapproved. Of course, we have not made that decision yet. But what is the enforcement requirement after that? Is it fines? Is it demolition? Is it?
So if the variance is disapproved, then either way, the shed would need a permit. Obviously, staff can't grant a permit where it's in its location. The shed would need to be relocated. So the applicant would need to submit a permit application for the new location of the shed. Whether it's 1.5 feet over and one way and 4.5 the other, wherever he decides to relocate the shed, we'll need, and then we would work with the applicant as far as time frame to, actually have that shed relocated. Obviously, it would take him a little bit of time to kind of work that out, and we would certainly work with the applicant in that regard.
Sure.
Our goal is compliance, not.
I get it. I'm throwing out some hypotheticals here. If the variance should be disapproved and he chooses to do nothing with the shed, what happens after that?
Yeah, if the applicant chose to do absolutely nothing and just say, I'm going to leave it, then yes, our only recourse would be civil, or would be criminal prosecution. We would file charges for not locating the shed, for not being compliant with the zoning code. So, which is a misdemeanor offense.
Okay.
So.
All right. Thank you. I don't have any further questions right now, Mr. Ellis. I'm going to ask for seconds.
No, I'm ready for a discussion, but I don't need any further questions from the applicant or the.
Okay. What's your discussion?
I guess I'm sort of torn here and have great sympathy for the applicant. He relied on professional opinion of his contractors that obviously gave him bad advice. The part I'm torn about is that he in effect is replacing a shed that was already there. Now the shed that might have been there might have been illegal. Maybe it was built before the city incorporated or before the zoning code. I don't know if Matt knows that part. But it's a very nice shed. It's an expensive shed. I think it's a real asset to the neighborhood. And to force the applicant to move the shed just because it's in the same spot as a non-compliant one, I think is a little bit of, I'm having problems with that.
Okay.
We're in effect replacing a non-conformity. Yeah, I know the zoning code says that when a non-conformity comes up that we should make it conforming. But in this particular case, I'm having a real difficulty justifying that.
I have same concern with Norm is talking about that, a lot of money has been spent and is a kind of permanent structure, concrete pad, and, because 4.5 feet encroachment, and if we don't allow as it is, then there's a lot of hardship on the part of, our resident to just kind of demolish or move other more 4 feet to more left. It's a lot of hardship. So, yeah, staff has done their job they're supposed to do. They're looking at the compliance, and we do look at the compliance too. At the same time, what adverse impact it will be if it stays as it is, and not to demolish and move. So I have sympathy and empathy, whatever you call it, with the resident.
Got it? Got anything?
No, I just agree with everything that's been said, and correct me if I'm wrong, but I don't think we received anybody from the community who said anything negative about the shed being there or anything to that effect. So a lot of public support from neighbors and everything.
Matt's got something to add.
Go ahead.
I would just point out that this all originated from a complaint from a resident, so.
Gotcha. Okay. Gotcha. An overwhelmingly positive.
Yeah, Mr. Ellis, I know you're going to ask the question, and I don't think Matt has that information about who made
Yeah,
the complaint.
All the neighbors that are within visual range of my property, and including, you notified within 500 feet, a resident from a whole block away that has absolutely no idea, not him, an additional person, but him as well, who said, that's ridiculous. So I'm not sure how somebody could complain about that. Are you sure that it wasn't your inspection of the property via the overhead satellite that you made the determination that it was?
Please direct all your questions to the podium, please.
Pardon me, I was not aware. So I don't know who could possibly complain about that shed.
Well, it could be anybody driving past your property that sees a shed that's too close to the property line, right? I mean, it doesn't have to be anybody who's a direct neighbor or, anyway, we don't know who that person is. Well, I don't even know that it's advisable for us or pertinent for us to find out who that is, but just be aware that there was a complaint made, right? Which led to the inspection and the citation, not the other way around.
Unbelievable that someone
Yep.
could complain about an improvement to the community. Is there anything else for me, sir?
No, sir, not right now. Thank you.
Thank you all.
So I suppose my comments, obviously, I agree with Norm and Sunder about this and Cullen. I'm having a difficult time with it because on one hand, I don't want to set any sort of precedent where we're saying it's okay to ask for forgiveness as opposed to permission, because that's certainly not what we should do or what we're allowed to do. We've had similar cases, not any, I think, identical to this, certainly, and I wouldn't want to make any sort of decision conflicting with something we've done in the past. That being said, I do feel, at least to put this on the record as well, that this is different than a lot of other ones, and that this was in good faith done. This was not Mr. Ellis's fault. In fact, he relied on people who would generally know what they're talking about to make that decision. You would think the contractor would pull a permit or would understand that there's a requirement for a permit for this sort of thing. They didn't do that, and it's a shame. I wonder if a conversation with the contractors makes sense, a threatening letter from an attorney or something like that to say, I don't know if there's a contract or if how you entered into this agreement with them, but I would imagine that they were required to provide a shed that complied with all laws, and they didn't do that. So that's one thing that crosses my mind as being an avenue that should be explored or could be explored regardless. I don't think I'm necessarily saying that we should table this as we've done before, but that's something that just strikes my mind as being a potential next step. But again, I do agree that it would feel wrong to require the shed to be moved. It is a nice shed. Nobody seems to have any issues with it.
I just wanted to very briefly just remind you guys of the Duncan factors and the fact that we're supposed to stick to the code requirements. And obviously sympathy is, I think, deservedly so. given
If
his
you would
remarks.
like me to, I can go through my reading of the Duncan factors.
Sure, you can. I just wanted to mention, because we talked about the cost number 8 in the list, where you're not supposed to consider just the purely economic cost to the applicant.
Understand that.
I just want to bring that up.
I appreciate that. And that's one of the things that I've been working here, sitting here, going through the Duncan factors and interpreting them the way I would see it for this particular case, no other case, because the only evidence that's been presented to us is what we can consider. So I've been sitting here going through the Duncan factors, and if and when I make a motion, I will have considered all of those. Thank you, Counselor.
Okay. Anything else for the good of the order? If not, I will entertain a motion to either approve or disapprove V 23-7 variance request.
I move the motion to approve the variance to allow the shed the way it is right now.
Okay, I have a motion to approve the variance request. Do I have a second?
I will second that based upon my interpretation of the Duncan factors.
Okay, I have a motion to approve and a second to approve. Ms. Gillow, will you call the roll, please?
Mr. Clunin,
I vote to approve.
Mr. Essman,
To approve.
Mr. Rust,
Approve.
Mr. Botla,
To approve.
Mr. Archibald.
Approved. Okay, Mr. Ellis, you're free to leave your shed where it is.
Thank you, sir.
As far as zoning goes, you may still have an issue with other permitting processes that are not within our realm, but
Yes, so I will need now to request a building permit for the building?
Well, I'm not sure how that, does he need the permit now that the variance request has been approved?
No, the applicant will still need to apply for a variance permit, and obviously the decision of the board will be taken into consideration on the granting of that variant, or of that zoning permit. The applicant will need to contact the building department to make the determination as far as, obviously, how we calculate the square footage of that structure may be different than how the county calculates it, but they require a building permit for anything over 200 square feet. So whether or not they'll require a building permit, at which point the applicant will have to, apply for a building permit and, basically make sure that it's compliant with our local building codes as well as our zoning codes.
Okay, and that building permit is through the county?
Correct. Through the zoning codes, the zoning permit is through us, and he'll need that before the county would even consider his.
so the applicant's next step is to apply for a zoning certificate from you.
Right, correct.
Thank you.
You got that, Mr. Ellis?
Yes, sir. I would also like to point out that the shed is 130 square feet,
Perfect.
and there is covering which extends out from that,
Yep.
which extends out 10 more feet, which is not
Closed.
permanent structure, it's open area.
Well, I think Mr. Funk's point was that the county will determine whether or not that is included or not, right?
Okay, so apply for
A zoning permit through the city,
zoning permit through city.
and once you get that approved, with this variance request attached to it, and you go to the county for a building permit.
Just request, just ask, you just confer with them as to whether or not you need a building. They can look at your structure and everything and tell you whether or not they would.
Would it be okay if I contacted Mr. Funk later to get more
Oh,
details on
absolutely.
this?
We highly encourage that. Yeah,
That'd be encouraging.
Thank you all for your consideration.
you're very welcome. Okay. Good discussion. We have another case tonight. It is V 23-8. Ms. Gillow, can you tell us about it?
This is case number V 23-8 on an application filed by Calvary Engineering Incorporated, 7700 Paragon Road, Suite C, Centerville, Ohio 45459, requesting a variance from Chapter 158.037 F3 of the City of Beavercreek zoning code to construct an addition to the existing Domino's Pizza building within the required 30-foot rear yard setback. The property is located at 3320 Dayton-Xenia Road, further described as Book 5, Page 5, Parcel 164 on the Greene County Property Tax Atlas.
Okay, thank you very much. Mr. Funk?
Thank you, Mr. Chairman. So basically what we have before us is a variance request for 3320 Dayton-Xenia Road, otherwise known as Domino's. And they're located down here near Fairfield Road. I'm sure many of you probably passed it on the way here.
I've
So
been
here's,
there.
In full disclosure, I did drive by this, this site on the way here today.
so here's our, you didn't drive by this way on the way here, but here's our drive-by of the Domino's location. I'm sure most of everyone is familiar with that, being residents of Beavercreek. So the applicant basically is requesting, somehow I'm missing slides, I'm sorry. Anyway, in your packet,
Yeah.
you will see, I don't know why I'm missing those slides. I apologize. In your packet, you'll see the applicant's site plan. It will be, basically, there's a color photo and also just a drawing that shows distances. The applicant is asking that the shed be located to the, not a shed,
Walk-in freezer.
a walk-in cooler be located to the rear of the existing building. So it's basically going to encroach a little bit into that rear yard setback. And so the applicant basically is requesting an encroachment into that rear yard setback to allow for that walk-in cooler. The applicant originally, you probably saw if you look through the applicant's request, they asked actually for a side and rear, but because the building already is encroached within that side yard setback, that's not required. They just need the rear yard setback. So basically, they're requesting that the building, the walk-in cooler that addition be located to the rear of the structure. Staff basically went through the analysis of that and basically, let me get to that. Basically, staff feels like we believe that the criteria 1 has been met mainly because of the location of the building on the lot. It's shifted to the east and the north of the structure. So the really only viable locations for a walk-in cooler would be to the rear of the structure or to the side. And so that west side of the structure basically is where their parking lot, deliveries, all that kind of stuff. So staff does not, really believe that would be, probably the best location for the walk-in cooler. And based upon that positioning of the building on the lot, staff feels that there is a practical difficulty as far as the availability of locations to put the shed. The second criteria is that the minimum variance possible, and staff believes that it is because it's not encroaching that much into that rear yard setback, and so and there's still going to be ample of space behind the structure. They're saving the majority of that rear yard parking or that rear yard green space behind the structure. There's still going to be nearly 24 of the 30 feet available for open green space. So, staff believes that probably is the minimum variance possible. The third criteria: will the granting of the variance be in harmony with the general spirit and intent of the code? We believe that it is. If you look at the surrounding buildings, if I go back to that aerial photograph, you can see to the kind of to the north, you have the Muffler Brothers, and then to the east, you have CVS. And, the rear of that building, of the Domino's building, is virtually unseen from the public unless you're in the CVS drive-through. You can't even see, back behind their building. And so, and those buildings actually, particularly the Muffler Brothers encroaches, well within, they're clearly not meeting any kind of rear yard setback requirement. But they're very close to the property line already. And so, even though there is a variance request, it's a minimal request as far as distance. They're still preserving the majority of the green space. So we think in general it does meet the spirit and intent of the code. The criteria 4 would be injurious to surrounding properties. Staff does not feel that it would be injurious, nor the next one, would there be a deleterious change to the character of the community. Again, you're not even, for the most part, you're not even going to know that the walk-in cooler's there, because it's going to be out of sight unless somebody's, like, say, coming through the CVS drive-through. And will it infringe on the quiet enjoyment of the adjacent property owners? Again, staff does not believe it will. And to the point of, even from Muffler Brothers, you had the Muffler Brothers building, and you can see, let me, if I can pause that. You can see when I start this video, even in front of Muffler Brothers on the left-hand side, you can see a privacy fence that goes across. So even from the remaining area of the Muffler Brothers, the property the Muffler Brothers on, shields the back of the Domino's building from even view from that building. Staff does not believe it would infringe on the rights and quiet enjoyment of adjacent property owners. Staff also, number criteria 7, does believe that it is for a compelling reason. Even just from an aesthetic standpoint, to have a walk-in cooler on that west side of the building where it's seen from the road and, out of character with the rest of the building and all that kind of stuff, to locate that into, to the rear of the property where it's going to be out of sight, nobody's going to see it. There's still plenty of green space.
Is there a rendering of the proposed addition?
I don't think so, no.
Thank you.
Typically, and the applicant can address this when he comes up, typically walk-in coolers are kind of a silvery color, and they kind of stand out.
That's my concern.
Yeah, they kind of stand out. And so by locating that to the rear of the building, again, it puts it out of sight of the general public, and it's not really something that we would want to, aside from disrupting the flow of the traffic flow in the parking lot and all that disruption of potentially deliveries and all that, it's going to be somewhat of an eyesore, I guess, to be on the side versus the rear. And the last criteria is the granting of the variance solely for an economic benefit of the applicant. Staff does not believe it is, because whether they locate the addition onto the rear or onto the side, cost-wise, there may be a cost difference, but it's got to be nominal to the overall cost of the installation as to what side of the building they put it on. So it's really not necessarily for the economic benefit of the applicant. It's really, in the best interest of the community for it not to be seen. So.
Okay, thank you, Mr. Funk. Since this is a can we hear from the applicant, please? A representative of the applicant. Sir, if you would mind reading the card up in the upper left-hand corner of the podium.
My name is Art Harden with Caliber Engineering, 7700 Paragon Road, Suite C, Centerville, 45459.
Okay, thank you.
Testimony that I'm about to give before the Board of the Zoning Appeals of the City of Beavercreek is the whole truth to the best of my knowledge.
Okay.
To address your first question with regards to do we have a rendering, there's not a rendering of, we don't have one of that, but generally there are a lot of restaurants, and just to give you an idea, we're building an Outback right now in Eastgate, and they have a walk-in cooler. So a lot of restaurants, a lot of facilities are going to the walk-in coolers. With regards to the color of it, what I would offer is that we could paint it so that it kind of blends in with the building or something, so it's not something that's a big silver box sitting back there. But most of them are colored and painted. So with that, as Matt said, this is what we feel is the best location for it. Obviously, from the roadway standpoint, you can't see it. It's not going to be visible, and the only people that are going to see it will be anybody that drives through CVS or going back to the muffler shop. With that, we're wanting to start construction as soon as we can possibly get all our approvals and everything, and get the facility in its best operational mode.
Okay, great. Thank you very much. Well, I'm sure we'll have questions.
All right.
Since this is a public hearing, I will open up the public hearing for anyone to present comments for or against this variance request application. Ms. Gill, do we have any written input? No. Okay. Hearing none, seeing none, I will close the public hearing and open it up to board discussion. And since Mr. Clunin gave me a hard time last time, I'm going to start with Mr. Rust this time.
I'm good. Just cruel to do this around dinner time, though. Honestly. No, I'm good. Thank you.
All right, now, Mr. Clunin.
So just so I understand location-wise, and Matt, maybe this is best for you. Maybe if we have can you put a picture up?
Yeah.
Or
I
overhead view,
apologize to my,
whichever one's
I had a
fine.
couple slides that are not in there, and I apologize for that. So basically, if you look in your packet, there's a sheet like this that shows the dimensions and the location, the walk-in cooler being yellow. And then there's also another color picture as well that shows basically the location of the, like an aerial view with the location of the walk-in cooler on there, and also in yellow. Like I said, I do apologize for not having that slide.
That's fine. So my question for you then, Matt, would be, obviously it's going in the back, the north side, or the idea is for it to be on the back side of the property. Technically, no variance would be needed if it was on the west side? That
Correct.
would be, okay. And the purpose seemingly is outside of maybe convenience and it just working better on the back, that it's going to be more aesthetically pleasing to the public if it's in the back and not so everybody sees it.
Certainly, that would play into it, yes.
Okay. All right, that's what I thought. That's all I've got then.
Okay.
Thank you, sir. Nothing.
Mr. Bala.
Thank you, Mr. Chairman. Don't have a question, but just a statement. Would you be applying for building permit?
Oh, yes.
Okay. Just want to make sure, that's all I have.
Yep.
Okay, so, come on up. I have a couple of questions. So, this building has been there for almost 30 years, right?
Oh, it's been there longer than that.
Well, I mean, as Domino's, it's been there for
Yeah,
like
well,
30 years.
Domino's has been there quite a while, but in doing some research to the USGS maps and going back as far as I can with them, I went back to, I think it was 1956, and there was still a structure there. So it's been there a while.
Before the city was a city.
Before the city was a city. So, and that's probably where the condition came about with the close proximity of the property line. You know, back then, there were not the regulations you have now, including the muffler building behind us. We actually did a field survey, and that's what we've represented in the packet.
Okay.
with this document.
Got it.
Those are actual field dimensions that we went out and measured. And the muffler building is about a foot off the property line. So, but that's what we have at this
Okay.
point.
And where would the entrance to the walk-in cooler be? Would it be on the west side of the cooler?
It will be basically, there is an architectural drawing that's in the packet. Go back to it. Although the architect did not have the correct property dimensions on. There's a drawing called A1 in your packet.
A1. Okay.
And if you look at your packet, you can see that the equipment dimension and floor plan, that the walk-in cooler is there, and then there's a door and how it's laid out on that. If I can approach.
We're not finding an A1. And while we're passing that around, is there an exit from the existing Domino's building to the rear that would be like in front of where that cooler's going to be?
No, this would be a new door. Is my understanding.
So the only access is from within the Domino's.
Correct. There's no exterior access.
Oh, okay.
Oh, okay. So there's a penetration into the existing building
there it
to
is.
access the cooler?
Yeah.
Okay, so that's a part of construction.
Yeah, so no one, it would be, basically become part of the building, and all access would be
Okay,
through
yeah.
the building itself.
Yeah, yeah.
Okay.
Okay, yeah, I see that, yeah. There's a door and everything, yeah.
And since Domino's has been in business there for so long, what's the compelling need for a new cooler at this juncture?
Well, I would say part of it has been COVID. The demand for deliveries and pizzas deliveries and everything, just any kind of delivery of food has gone way up. They have some cooler space there, but not sufficient enough for what the demand is under today's market.
Okay. All right. Thank you very much. Matt, I have a couple of questions for you. It's kind of hard to tell. Is that actually green space behind that Domino's?
It is green, yes. There is grass back there.
Is it grass or is it painted green?
Oh, my God.
It is truly
Yeah,
grass.
I see that, it's a green. It's a green there.
And does that privacy fence, does that stop like right before that first auxiliary structure?
Yeah, let me run this video again. I can't, maybe I can stop it here.
Oh, there it is. Yeah. Do you- Would they be running that privacy fence further? Is that Domino's privacy fence or Muffler Brothers privacy fence?
I'm, with the landscaping and stuff on the Domino's side, my guess would be it's probably the Domino's fence and landscaping. I'm pretty sure, I'd have to go back and verify with checking the, zoning permits, but I'm pretty sure that it was screening that Domino's probably added
Okay.
to separate the two properties.
Is that required screening?
Since Domino's was already existing, I don't know that it was required.
It wasn't required.
It was
Thank you.
probably something they chose to do for their own aesthetic benefit.
Absolutely.
All right, so let's talk a little bit of history here, because I was a little confused by reading the report.
Okay.
So the current, this is B2, right?
Yes. I do
So the current B2 requirement is 30 feet rear setback and
Yes.
15 feet side setback, right?
Yes.
And this has been grandfathered because it violated that from the beginning.
It's one of those non-conforming structures we've been talking about.
Right.
Yeah, so it's
More-
legally
more the
non-conforming.
Right.
So obviously, if Domino's was to build a new Domino's there, they would have to bring it in conformance with our current zoning requirements. And I'm sure at that time, they would factor in the walk-in cooler at that time as far as their location on the parcel.
Sure. So, I know that in previous discussions we've had where we want things to come into compliance when we add something new, right? Is there not that requirement for putting that walk-in cooler 15 feet from the side property line?
I mean, they could, you're talking about relocating the walk-in cooler to the west side of the property instead of the north side?
Just shifting it down the back side of the building.
Oh, they certainly could, towards CVS?
No, the other way.
I mean, yeah, I mean.
Heading west.
Yeah, either way, I mean, either way, they don't need a variance for their side yard setback, but it's only the rear that we're looking at tonight, because, they could be as close to that east side property line as their existing building, because it's already non-conforming. So they could move it that way, so the only variance they need is the roughly 6 foot to the rear.
Okay, so I guess really the answer to my question is that in order to to put the walk-in cooler in compliance, the whole building would have to be put into compliance.
Yeah, I guess you could say that.
Yeah, right, okay. All right, thank you. I don't have any further questions. Seconds, anybody? All right, hearing none, I will entertain a motion to either approve or disapprove this V 23-8 variance request.
Motion to approve?
We have a motion to approve the variance request. Do we have a second?
I second.
Motion to approve, blah, 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 blah. A motion and a second to approve. Ms. Gillo, will you call the roll, please?
Mr. Essman,
Yes.
Mr. Rust,
Yes.
Mr. Bottler,
Yes.
Mr. Clunin,
Yes.
Mr. Archibald.
Yes. Okay, that variance request has been approved, and good luck with the building permit and all that other kind of good stuff. I'm sure they'll make you do all kinds of fancy painting and stuff to match the building. And
All right. I'll see what I can do about that.
okay. Anything else for the good of the order? All right, hearing none, I will entertain a motion to adjourn this fine meeting.
Move to adjourn.
We have a motion to adjourn. Do I have a second?
I second.
I have a motion and a second. By voice vote, all in favor? Aye.
Aye.
Any opposed? Hearing none, we are
Adjourn.
adjourned. Thank you.
Time for dinner.